I want to share with you an actual transcript of closing remarks that I made in a case I tried back in 1990. Come join me as I share with you this remarkable information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law here in the state of New York. Before I began my career representing injured victims, I actually started out doing defense work where I was representing people who were sued. Now, I was going through some old papers I had in the house, and I came across a transcript of a case I handled back in Nassau County in Mineola in May of 1990. So let me set it up for you. So in that instance, I represented a winter resort up in the Poconos Mountains. And here we had a 34-year-old gentleman who went up there with his wife and a couple of friends. And this was a sledding accident. This guy gets on a flexible flyer, a plastic disc. He takes it from somebody else's porch, and now this big, huge guy gets on this plastic disc that has no controls. And the thing does what it's supposed to do. It starts to spin. And as it spins, he's going down backwards, and toward the base of the mountain, he winds up hitting something, now causing a fracture to his tailbone, to his coccyx. That's what this case is about. And here I was representing the owners of the property, and I was arguing that this guy should have known about all the inherent risks associated with this type of activity. So come join me as I continue on reading to you the closing remarks. This is now part 2 of the closing remarks. In another video, I shared the beginning part of it. All right, picture this if you will. Beautiful northern Catskill region. Beautiful country area up at a place called Winter Clove. It's winter, January 1984. It's a cool windy day. It's a nice day. It's late in the afternoon. It's 4:30, 5 o'clock. It had snowed recently. A foot of snow on the ground. It was a beautiful place to be. Fresh air. What a wonderful place. So what do we have? We have the plaintiff and his wife going to a hill that they claim they were directed to. Going to a hill that they got on and started to sled on. Now, who was it that directed these people to go to this hill? Who was it? In 1982 or 83, whenever they were there before, somebody directed them to this hill. In 1984, the time that this happened, somebody directed them to this hill. They can't describe them. They don't know if it was a man or the woman. They can't tell you what they were wearing. They don't know who they were. Now, what was important for you to understand is that they claimed that there were no signs, and in fact that somebody from the resort had directed them to sled in this particular area. And that was a total lie. So now I continue on. But isn't it convenient, ladies and gentlemen, that these people can't describe who they are, what they are, when they did, and so on? But there are a lot of other inconsistent details about this case, a lot. I submit to you that no employee of this hotel ever directed these people, and the plaintiff's attorney objects. Objection to that, Your Honor. There's no testimony in this case. And I said, this is my conclusion. And the plaintiff's attorney yells out, it's not his conclusion, objection. And the court says, Counselor, don't interrupt, meaning the plaintiff's attorney. Don't give me arguments. You've made an objection and exception. The objection is overruled, meaning that I can go ahead and continue on with my closing remarks. Counsel is doing what I've instructed the jury that you are both entitled to do, which is to give your impression of what the evidence is in this case, and the jury will then determine. You are giving an argument and only an argument. Go ahead, counsel. And I continue. Thank you, Judge. I submit to you that no employee of this hotel ever told these people to go use this hill. That if they were to ask, and if they had asked, that they were told to go to an area much farther away from the main house, a place by the bowling alley. And who better to know this than the gentleman, the owner, who was there himself? This is someone who is the son of the owner who worked at Winter Clove all his life, who grew up there. He knows where people are supposed to go sledding. He knows that if people ask, they're directed to the slope by the bowling alley. Well, that's it for this particular segment of these closing remarks. In another video, I'll continue on, and I want you to see exactly what it was that got the jury to realize that this gentleman should have been responsible for his own actions. So I hope you'll join me on the next video as I continue on with the closing remarks here. And as always, I realize if you have questions or concerns about your own particular matter, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, @oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.